What's up, everybody? Welcome back into another episode of The Lawyer You Know, and we are going to be breaking down the latest Karen Reed hearing. And so many of these hearings are interesting for different reasons. And I got to be honest, I was a little surprised at some of the details as they came out through the lawyer's arguments. Some new details revealed make me think some things, and then some descriptions made by Hank Brennan. I'm starting to think, well, is that really what happened? What we read in the defense's motion, and then Judge Cannoni's questions, I thought were really well thought out and well done throughout this hearing to let us know kind of where she is, but also that I think she's thinking about this the right way. What is her decision going to be? We'll talk about what I think, but of course, we'll answer your questions as always, and some concerning things at the end of the hearing that may create an issue with the start of this trial being on April 1st of this year. All right, so we are going to start out right in the beginning because I really enjoyed is probably the wrong word. I liked listening to the arguments from both sides because when we have motions and responses written, a lot of times lawyers just regurgitate the same exact thing. And while there were some similar details in the arguments that were in the papers, there was a lot of additional context and a lot of additional argument. And it's always interesting and sometimes bad. You don't want to become part of the case. You don't want to become the subject matter if you're the lawyer. But a lot of it became, hey, these are the conversations we had with each other. This is what Mr. Brennan told me. This is what Mr. Jackson told me. And the judge has to sit there and, as the fact finder in a hearing like this, determine who's telling the truth and who's not. And if the truth is somewhere in the middle, or if there's a difference of opinion or different way you can kind of look at and break down what was said, how do you make that decision? What's fair? What's just? And so we're going to listen to the defense's argument first, since it's their motion. They want the first part of it is they want the fees and costs of the expert that showed up to Canton Police Department to copy the video just to find out nothing is there. Total waste of $12,000. The Commonwealth says not so fast. That's not exactly how it went, because the defense says, hey, they sent us on a wild goose chase. They told us, yeah, come and get everything. Come on down. We're being transparent. Come download all the video, knowing full well there was no video. Brennan says that's not how it happened. But we're going to listen to the two lawyers make their arguments to the court, starting with Mr. Jackson.
Ma'am?
Yes.
The court started by asking, what is it that the defense is asking for? Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness. And the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice. And those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing. And that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth.
So it's important because we're going to watch Brennan's argument after, but you'll notice when Jackson mentions Rule 14 or discovery violations, that's a little different than his motion to recover those costs. And Brennan brings that up and said, I wasn't necessarily prepared to argue that. If we are going to argue that, let's do it at another hearing when I can bring all of the procedural history in this case to figure out what actually has been asked for and what hasn't. Jackson's kind of making these arguments together, which I think is a very good argument, but maybe they'll have to have another hearing to discuss the discovery issues if we get there. I tend to think we won't.
Indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is, and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now, defending herself against provably false allegations. And at the center of that storm of defense are these Sallyport videos. It should be pretty straightforward. really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's 24-hour period, 23 hours and 59 minutes.
So it's always a really great argument when you're asking for something that is always readily available, should be produced, that exists for these exact reasons, right? To make sure law enforcement doesn't do anything wrong and that they can prove that everything they did was appropriate and nothing nefarious was going on. We even have the surveillance videos. Now, on the other side, law enforcement could say, how would we have ever thought you were going to say this had turned into this big cover up? Of course, we didn't think you were going to argue that because it didn't happen. So that's why this is no big deal, just kind of our internal cameras that are covering the Sally port. It's like, well, if you're saying that the weapon used to take a life was a car and that's where you parked it and you did testing on it, you probably should know that the video and the surveillance around that was going to become important. And I think the defense has a pretty good argument that since somebody downloaded it somewhere and shared parts of it, that ended up trickling into the hands of the defendant throughout these years-long processes, all the way up until very recently, we're going to hear they're still turning over bits and pieces to this video that they say doesn't exist in its original form, but at some point it had to be downloaded. And we'll get into whether or not notices for preservation or to turn this stuff over was made appropriately by the lawyers involved. That's important, but only partially important to this actual hearing we're here about today, which is, should the Commonwealth have to reimburse Karen Reed for the expert expenses for sending her expert to Canton to download something that didn't exist?
It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence.
So February 2nd is what, 2 days, 3 days after this happened? So well within the 30 days. Judge Cannoni, again, that's the right question. When did you request it? Because if you requested it after 30 days, it's tough. If you didn't tell them to preserve it, that's tough. I mean, I think it's horrible that law enforcement purges everything every 30 days. But then again, it's community resources, public resources to pay to keep this stuff and to store this stuff forever. If you keep it forever, it's more expensive. So that's how they get there, in case you're wondering why they purge things every 30 days. Because if they kept every body cam footage, every security footage in the Sally port, everything everywhere, it's very expensive. Now, maybe cloud storage will help with that. But I remember when I was on rules committees or when I was fighting this stuff at trial in some criminal cases, that's how they would always explain it, which it makes sense. But in this scenario, it was requested is maybe the wrong word, but they said, you need to preserve this. We may need it. And he even calls it a catch-all. And that's fine, because you don't know what you're going to need and what you're not going to need. But everything that you guys have that could be pertinent to this case, preserve it. That's what they did on February 2nd. They did not say, send us the Sally Port video on February 2nd. I have not seen any documents that say that specifically, because at the time, they didn't know what existed and what doesn't. I'll just tell you right now, I've been in Pinellas County Sheriff's Office a million times. I've been in Clearwater PD. I've been in all sorts of law enforcement offices, agencies, jails, all over the place. I don't know where they do have security cameras and where they don't. I don't know what they record and what they don't. I don't know what's public and what's private. So I would just say, keep it all. Same thing if it happens at Walmart, right? We don't know exactly where every security camera is. So we just say, save everything, because we don't know what we're going to need. And that's what they did on February 2nd.
Been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been.
I'd like that. I mean, that would be.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download, before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons, and I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained.
Okay, so how do you ask for something? How do you ask for what you, How do you ask for what you don't know exists? Janet asked. Great question. Lawyers do it all the time. And it sounds a little something like preserve all physical evidence. Now, they could argue, oh, it's not physical evidence. We thought that was DNA and the car itself and blah, blah, blah. But videos can be physical evidence too. What I'll say is most of our spoliation claims or notices of preservation will say pictures, video, data, things like that. And we're being broad intentionally because just like Janet said, you don't necessarily know what you're going to need and what you're not, but anything that's in the possession of law enforcement, anything that's in the possession of a private person or private company that you think may help in a case and you send them a spoliation letter, that's really all you can do. How does the Commonwealth not have retention requirements for the Sally Port? So I don't know what you mean. They've got a policy, and that's to delete everything every 30 days. So I don't know if you mean like when you get a preservation, how does it not go to somebody and they save it appropriately? Well, sure, that's how it should be. And I'm going to get into this a little bit more when Hank Brennan explains what their policy and procedure is down there and just how it's horrible. And it's a way that, and this is not just Canton PD, but law enforcement everywhere has policies that they can hide behind that allows them to do certain things, in my opinion, that just isn't fair to your common citizen. Bettero's fangirl. Peter, how can Hank continuously get up there and lie, mislead, or distract facts in this case? Is this not a violation of your rules of ethics? So here's what I'll say. Both lawyers have accused each other of misrepresenting things. People on all sides are pointing the finger saying everybody's lying. So when somebody provably lies, right? And Jackson's about to call all these claims provably false. When somebody provably lies or they can prove perjury, then fine, then we'll discuss it. But I don't know what happened, right? I wasn't on the phone with Brennan and Jackson. I know some people obviously think what Jackson said is true and what Brennan said is a lie. There's some people that think what Brennan said is true and what Jackson said is a lie. I don't know. So we're sitting here like the judge trying to figure out what's the most reasonable version of the events. Is either side lying or are they just trying to use the facts to their advantage? So we're going to see kind of as we hear the two sides of the story, what we think actually happened.
That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand.
And he makes a really good point and a really good argument that regardless of whether or not it was requested to be preserved, regardless of whether or not they actually asked for it in a single discovery question, it should have been provided because it was potentially exculpatory evidence. That's Brady. They didn't turn it over, and therefore that's a violation. That's a very good argument, in my opinion. We'll talk about what parts we think are actually Brady.
But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it.
If you delete it after 30 days, obviously you've failed to preserve it forever in perpetuity. Pebbles, a Brady violation is what Alec Baldwin basically went free for. Yeah, multiple violations by, and maybe even prosecutorial misconduct. We'll see, because now there are lawsuits pending. Janet, thanks. I always thought being broad was so unfair, just how my mind works. Now I see it had to be done that way. I agree with you generally, Janet. And when you get to a certain point, you have to be more specific. You can't just ask for everything to be produced all the time, right? But especially at the beginning of the case, like at least just don't destroy stuff. So if we ask for it later, or it does become relevant later, we want to be able to secure it, because it's so unfair if something's outside of our control, outside of our possession. We can't force or do anything with this stuff as the defense in a case. That's why when I talk about, criminal defendants and their rights and the presumption of innocence, everybody's like, all these rules are written so in favor of a criminal defendant. And I'm like, yeah, they are, but that's because the system is so stacked against every person accused and arrested and prosecuted for a crime. They've got everything. They've got all the witnesses, all the evidence, all the resources in the world. People want to help them. They're the ones fighting for justice, right? We're the scummy ones trying to keep criminals on the street. That's the narrative, right? That's what criminal defense lawyers are looked at versus prosecutors who fight for justice. And the good ones that do, we need them. Bless them. But the process must be fair, must be balanced. And this is one of the ways to do that. Just asking for them to preserve evidence that may or may not become relevant in the future. It has to be that way.
What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, and within their own time frame to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame. The missing portion is the exact time frame that the SUV was being pulled into the Sally Port. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sally Port, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions.
And it's like when I'm coming into the trial, right? And I didn't know anything that happened before, wanted it to be like that. The second trial is going to be much different, obviously. And you're like, oh, video, it's inverted. You know, what does that prove? What does it not? But then when you start to look back and listen to, this is stuff that they has to be preserved. They asked for 1,000,000 times, even without knowing they sent their expert there. It's like at some point, somebody saved part of this video, and it's clearly not the entire uninterrupted video since there's cuts, there's people appearing and disappearing. It's inverted. It all just looks bad, right? And it's all going to go towards what Hank Brennan is calling the accusations the defense makes up until we knock them down. But in reality, it's like they shouldn't have this much ammunition to work with. And this all pretty much feeds into the defense's case. And now I think there's going to end up being witnesses called by the defense to say, yeah, we even asked you guys to show up. And what happened when we showed up? It didn't exist, right? Well, it existed at some point, and they're going to use this in cross-examination. They're going to use this to impeach law enforcement, and they're going to use it to make the prosecutor's office look bad too. I think all this stuff should be fair game in the second trial to go with, you know, the cover-up conspiracy, and that it could have been easily disproven if they would have just kept the evidence. So why didn't they keep the evidence? And the 30-day thing only applies if none of it ever existed and neither side could ever use it. But that's not what happened, because we know there are portions of the Sally Port video that do exist and were played at the first trial.
And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sally Port video just a few days ago, this one showing the Lexus backing into the Sally Port from some exterior camera.
I mean, that's crazy. Now, I'll tell you, these lawyers are very, very good. A lot of lawyers, I'll say, are very, very good at making a small detail seem like a big deal. But sometimes they are, right? The devil's in the details, they say. And to think that more clips in February of 2025 are still trickling out to the defense after this woman's life and liberty has already been on the line is wild to me. Now, if I'm the judge, I could be like, okay, fine, Sally Port video's out altogether. The defense say, well, no, we need that. It proves part of what we're saying. The sketchiness of this falls right in to what we're arguing. So now the car is being backed in from some other unknown area. Now, is that a big deal? Does it make sense? Does it go out and then just back right in? We don't know. And I get the defense's point is we can't really trust anything on this video at this point, which usually when people say that, I'm like, okay, yeah, of course, we can't trust the recording. Just like Relly. It's like, that's not me in the ASAP Rocky trials. Like, that's not me on the recording. It's like, even the state pretty much agrees it's you. But this one, it's like, there's a lot of stuff that doesn't add up.
And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, we'll provide the DVR, you can have him look at it, he can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd.
So he does more than that when Brennan gets up. And that's actually a really interesting part of the conversation. Jackson saying, don't touch it, don't look at it. It's like, the drum set in Step Brothers, like, don't touch my drum set. Don't even look at it. And then he comes down all sweaty. He's like, what are you doing? I was watching Cops. Definitely didn't touch your drum set. But it's like Jackson saying, don't touch it. Don't even look at it. Let's just do it together so neither of us can accuse each other of doing something to it before my expert gets to show up. So to me, that's an interesting, how Brennan is going to spin that conversation. We'll wait till his argument, but he spins it in a way that made me think. And I was like, oh, okay. Let's dig into this a little bit more.
Also, how am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said. And he accommodated that. He said, sure, we'll agree to that.
So did he say, don't download it in advance, or don't even touch it, look at it, don't even do anything with it until I get there? Because those are two very different things that could be an important distinction.
So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th.
And that's Brady. I mean, that's Brady 100%. If they had it, if they knew it. Now, if the Commonwealth never knew this tape existed, and as soon as they saw it, they turned it over, okay, they should explain that. But that's absolutely Brady, because they're basically saying Higgins was doing shady stuff. He went back to the police department to do shady stuff, was talking to people back at Fairview. What about the phone call? Who did you talk to? Again, the same thing with, should the defense have been able to get his phone? If they knew he was making phone calls the night of the crime at the police station where they're saying this stuff happens, would that have changed any judicial rulings on the download of their phone before they could get destroyed? It's a domino. And that's why these little details can become incredibly important when there's just way too many things for this to add up. That should have been turned over. Both sides should have known about it. It absolutely would have been so. And that's the thing about, a good defense that they put on a trial, they would have gotten into that had they had it. But they didn't.
Yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury. in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence. And that's
brutal. If that's true, and he has all these inconsistent statements under oath. I always talk about perjury being a difficult one to go for, but when you have an officer like him doing it, you can't be having that. That just people lose public trust in anything he would do as a job ever in the future.
Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that. The reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and Experts were retained and flights were booked and hotels were reserved and transportation was arranged, and all at Ms. Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days.
So then he goes into a little bit of what was in the document about what his expert did, how much it cost, that everything gets written over in 30 days, and how somehow they got some of this footage that they're still trickling out. But then he talks about somebody potentially saving it on an iCloud account, and they start getting into that, which doesn't sound great. And then he gets into the case law right at the end of his argument.
The Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us that remarkably, he went to Canton PD, and this is in his opposition paperwork in his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous.
Not at all surprising with how the investigation went, but just, I hope we're all learning how important it is that law enforcement does thorough, proper, and complete investigations. And when they don't, how many questions really can arise? And why is it a big deal? Because we've seen it in a lot of cases and people just assume, and I could be guilty of it too, right? They're a cop. They're going to do the right thing. They're generally good people. They're trying to fight for justice. They catch the bad guys. But that's why you got to document everything, do everything by proper protocols and procedures, and handle everything appropriately. Because if you don't, then legitimate questions start to come up.
What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire. And Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case is Justice Gaziano.
Vaith, I won't share your comment, but I like it.
Fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, so that's the end of the defense's argument. Edward said, scary thought. If Karen found guilty at first trial, do we ever find out about the extra footage? Prosecutors get away with this way too often. Never would we ever find out about it. First off, their discovery obligations would go away. They don't have to keep continuing discovery after been convicted. The appeal is based on what happened. They would have to somehow discover this new evidence. Hank Brennan wouldn't have existed. And you're going to hear Hank Brennan talk about how he showed up and he's like, oh, there's video footage that was never turned over to the defense. And Hank Brennan's arguing to the judge like how ethical he is. He's like, I'm so ethical, judge, I turned this over. And guess what? That is the ethical and correct and proper thing to do. But at the same time, when you're saying how ethical that is that you did that, you know what else you're doing? You're saying how unethical Lally and his team were. How did they not do either incompetent or unethical? How would you not turn this over? Dragon said, would it be possible for the defense to appeal an adverse Brady ruling before trial to an unbiased arbiter, or would that have to be after the trial? So feels like a little dig towards Judge Cannoni, but that usually would be something that's handled in the appeal post-trial. All right, now we're going to jump to Brennan's arguments.
Purposely conflates two very... It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever.
So he's saying they bring up the Rule 14 discovery violation issue because that's their better argument, but they didn't make it in their motion. So we shouldn't be making this decision on that today. Their motion for costs is meritless. I completely disagree. If what the defense said was true in their motion. Brennan has a little bit of a different description of the facts. Nina said, how are these late discoveries not Brady violations? So they certainly seem like they are. One of the reasons they might not be is if the Commonwealth did not know they existed and did not have them. And as soon as they had them, they turned them over, right? Because the Commonwealth can't produce things they don't know exists either. Should they have? And did somebody know and not tell somebody else? Well, will we ever know the truth is the question.
And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very...
So shots at Jackson and crew saying that when we have to go back and forth about what lawyers said, and we are, we're supposed to be in the profession of ethics and treat each other with candor and be honest with each other, to have to go back and forth, said, no, I didn't say that, I said this, is frankly embarrassing, Your Honor. Okay.
Skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere, and a lie unchecked becomes the truth. So now I must stand before you, and I must tell you what happened. When I entered
A lie unchecked becomes the truth. I do like that line. I do like that line. He definitely had that opening prepared and ready to go into his argument.
This case in September, and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began...
August of when? Do you guys know what that is? He saw a video produced by Canton Police Department in August and immediately turned it over. So I want to know, when was that August, right? Was it August of 23, August of 22? When was it produced by Canton Police Department? But regardless, you know who never turned it over? Lally. But was it after Lally was kind of off? I don't know. That's why the timeline's important.
A study of the case and try to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings.
And you see the words he uses, right? There was no motion to preserve videotapes. And I will agree with him that usually I do put that language in my motions, specifically video and photograph evidence. But all physical evidence, this is going to be some of the stuff the judge goes back and forth on. Is all physical evidence, does that include videos? Should they have had to save video? And if they didn't, is it Brady? Should they have just turned it over under their obligation? It doesn't even matter whether or not they were told to preserve it and requested it in discovery. By the way, I'm sure at some point they asked for video evidence, but I think what he means is it was after the 30 days within their procedure, they destroy it. But obviously they didn't destroy it because they're turning over parts of it and using parts of it at trial, right? It's not just like they're turning over these parts of it that might not be real and are no big deal. No, they're using them in trial.
Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did.
I love when lawyers talk each other up on the other side just to use it to say that they should lose. It's like, he did such a great job. He was thorough. He was meticulous. It was commendable, Your Honor. It was so great. He never asked for this, though. If he would have gotten it. Or maybe we would have preserved it if he would have said video. He did such a great job. He's such an experienced lawyer, which is kind of like a backhanded way of being like, they should know better. We shouldn't have these issues.
There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request.
He said he hadn't seen that in 30 years. He hasn't been a prosecutor for 30 years. I would say that is an unusual request. I would agree with him that that's an unusual request. I would also agree with him that he didn't have to allow it. I would agree with that.
But in the spirit of transparency, in an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth would download it and provide them a copy. She had no
That is true. That is true.
hesitation. So I called Attorney Jackson back and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had
So this is some of the important dialogue. Jackson, the defense attorney, expressed concern that there might not be anything on there. The video might not be on there. Brennan agreed with that concern. So now's where we're getting into some of the nuance that might be a very important detail as to whether or not the defense is actually entitled to their costs. Because the way I read the motion was the Commonwealth said, yeah, come on down, download everything. We'll have it all ready for your expert to come up here and, plug in his doohickey and download everything he needs. And it's like, and then we show up and there's nothing there to download. Why wouldn't they just tell us that? Well, if you both discussed it and you said, you can come down, there might not be anything here, but it's up to you. Have at it. Go ahead. If you want to waste the money, do it. And if it was with that understanding that the defense sent the expert, then I'm not so sure they should get their costs. They should definitely not do it again, right? Because they start talking about doing it again. And Judge Cannoni, I think, has some good ideas at what might be a better and cheaper way of doing that. But in reality, if they were on the same page that this could be a complete wild goose chase and this could be all for naught, but if it's a risk you're willing to take on the defendant, as the defendant to pay for all this, then go for it. And we'll let you have access, but we can't promise what you're going to get. That's very different than, yeah, come on down. We'll let you download everything. You can get all the information. You can test it all. And then we'll see if there's anything you want to use at trial. Two very different explanations of a potentially similar interaction.
the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR.
And then he adds that very important caveat that Hank Brennan, because I said, why don't you go down there and just see if something's even there to get? And if there's not, just tell them. That's what I was saying when I read Jackson's motion. And Brennan's like, he basically was like, no, I don't want you to go look. I don't want you to go check and see if there's anything on this DVR. Basically, because if nothing is there, I don't want to have to accuse you, Mr. Brennan, of deleting it or have something to do with it. So why don't you just leave it alone and I'll send my expert down there. That's what it sounds like. I don't know. I don't know what happened, but it feels a little bit different than initially thought from the defense motion. Terry Wright said, do you think there is a real chance for a dismissal? No, not at this point. I really don't. I really don't. Could Karen Reed still ask for a bench trial instead of a jury, or what's the deadline / process? Both sides would have to agree. I don't think that's going to happen. I don't think that's going to happen. Theoretically, you can waive your right to a jury right before trial and try to go for a bench trial if both sides agree. So it's not impossible, but I would be shocked. Chronic Christie, he's still responsible for Lally's misconduct. And that right there is a very good point, Chronic Christie. And Brennan's going to talk about that, how he absolutely represents the Commonwealth and he's willing to take it all on. And Jackson has something to say about it as well.
And respecting his position, providing a professional courtesy, I agreed. Didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it.
And I got to be honest, people hate this guy. I get it. I get where everybody is from the first trial. I understand the reasons for that. I'm with you on the shoddy investigation. There's all sorts of problems, but a more difficult and more annoying prosecutor would have fought the defense tooth and nail for every single step for them to try to do this download. They would have objected to it. We would have had to have a hearing. They would have had to have entry on land, some kind of order from the judge to allow them to. They would have to designate somebody. That person they designated would have to be the one to show up. You're talking about coming to the police station, right? It's not just like downloading something from Walmart. And they had somebody else come, and Brennan was like, I trust them. I don't know if he actually said that, but he let them show up. So he does have a decent line here of history of trying to do the right thing, trying to be ethical, trying to be transparent, trying to allow them to download this, right? He has these details that do make him look good. Because he could have been a lot more difficult through this process. I promise you. Take my word for it. From somebody that's dealt with some very difficult lawyers, he could have been extremely difficult in not allowing them to try and come and download this information.
And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day overwrite on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, MVR, back in July of 2024. And I know that from a report that was generated by the Commonwealth and given to the defense. So they should know that as well. That may be one reason why they wanted to come out. They came out on their own volition. I extended the courtesy as much as I could, made no promises. I was clear. I was very uncertain about what would be on this since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras. I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive.
That's so weird to me. Like, I would want to pose that guy and be like, why do you do it that way? Who told you to do it that way? You just came up with it yourself to do it that way? And why? Why do you preserve it like that? Because that's not even the appropriate or proper way to do it. We can't, trace it back. If a defense expert ever wanted it like that there's issues with that. Why would you ever do it like that? It's so weird.
That was news to me. I thought that was helpful. So I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them because they'd already been part of the process. I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information to give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause.
They turn a professional courtesy into an injustice for their cause. If you like Hank Brennan, you think those zingers really work. If you don't, they probably make you gag a little bit. Nina said he said the video was there in July of 2024. He said there was something there, right? Did he say specifically the video was there? They say, Jasmine, even still, why wouldn't they share? We overwrite data every 30 days so we know it isn't there. Defense could then have taken the risk, seems deceitful. I don't know if that's what happened. That's the problem is after listening to Brennan, it almost sounds like they both agreed. Now, they didn't know about the 30-day overwrite necessarily. That's definitely something the defense should have already known about that. With these issues with the video, they should have already known all of this. But that's the problem with the rushed first trial, stuff being turned over right before they went. It's really frustrating, really frustrating. Why would a retired detective be able to access that info? So I thought he was talking about when he was a detective, that's what he would do. Maybe I misunderstood that. It's possible. But we get a little rebuttal here from Jackson that I thought was good.
Yeah, on those. By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory.
And Brennan said, the case Jackson talked about, there were Brady violations, totally different than this. And Jackson's like, no. This is Brady.
that's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. It's there's nothing to see here. That's not true. It's a Brady case because the information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well.
How about Judge Cannoni understanding and almost agreeing? The part that's important to Brady, she said it. She said it before Jackson did. She's like, are you talking about the Brian Higgins part? That's very interesting to me. I just lost a comment. Somebody said, yeah, problem is they say it overwrites every 30 days, yet new video comes out 30 months later and continues to trickle out. So where is it coming from? Give us all the trickling little chunks and pieces you have. Where are you getting this? That would be so frustrating. Just imagine that. If you're like, hey, Peter, can I have the video? And I'm like, oh, there is none. Oh, wait. A year later, here's a chunk. Oh, wait. Here's a chunk. Here's a chunk. Here's a chunk. It's clipped up. It's inverted. And you never know when I might give you another chunk. And every chunk I give you helps your case just a little bit. Just a little bit. And a little bit more. Maybe a lot of it. So frustrating and not how it's supposed to be. But Judge Cannoni is the one that said, talking about the Higgins part. Even she agrees. It sounds to me like she agrees that's at least potentially a Brady violation.
The inverted video part is also Brady, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense of the Commonwealth. It's about Ms. Reed and the Commonwealth.
I agree with him. It's not personal. Brennan seemed like a gentleman, even though a lot of people online may disagree. It seems like they're working way better together, Brennan and Jackson. I personally don't think Brennan, if the Commonwealth does have to reimburse these costs, which I think they should have to, I personally, it doesn't sound like Brennan did it on purpose. It sounds like Brennan assumed that the police department wouldn't let an expert show up just to tell him it's gone, right? He probably should have maybe made a couple extra calls, but he's probably like, when he found out this happened, he's like, guys, seriously? That's what I envision, at least. Maybe I'm dead wrong about Brandon, but I envision him being like, how can you guys be this bad? How can it be this bad? But this is where Jackson says he took on for the Commonwealth. So he's got to eat it. All the garbage they left behind, he's got to eat it. He can't create a new case. And that's why when we start to talk about, Hank Brennan did, in my estimation, he made a good argument here. He did a good job questioning this witness. His cross-examination is going to be better, in my opinion. But we can't forget that Hank Brennan is going to have to eat the red Solo cups, the Stop and Shop bags, the Proctor texts, the connections with all these officers, the nefarious pasts of some of them, the night out drinking with the firearm left somewhere they didn't know, the Higgins phone calls, the Higgins randomly driving after drinking way too much to the police station. He's going to have to deal with all that. He's going to have to eat all those warts, all those bruises on the apple, as some trial lawyers call them, the issues with your case. So how is he going to deal with that? That's what I really can't wait to see in trial number 2.
But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over.
Okay, so see, that description made me think a little different. In August, Brennan found the video. So did Brennan find the video in August, or is August when the video was produced by Canton PD? That's what I'm fuzzy on, those details. If I was the judge, I would clear that up and be like, okay, so he found it in August. Did it exist prior or not? Hannah says, Peter, would you ever come in as a special prosecutor on a case similar to this one? I would love to be a special prosecutor. I think prosecuting cases is so fun. It would be so fun to be a special prosecutor. Not in a case like this one. I'd have to look at it, look at the entire file, do a full investigation myself to get my arms around it and make a decision. And this, from what I know, right, which is not everything I haven't gotten to see in the file, I would respectfully pass on this one.
Over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, et cetera. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from a DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right? So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean? Let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny.
And Jackson's right as well. And again, it's hard, right? I wasn't there. And if you're a judge, sometimes it's hard. You hear two lawyers give differing ways the story went. And Jackson's basically like, I didn't say don't touch it, don't look at it like my drum set. I just said, don't download it. Don't have your experts do anything to alter whatever's there. We'll come, we'll do it together so all of our hands are clean. Michelle said maybe the defense wanted to do this for the Commonwealth to reveal/admit to the shady way they preserve stuff on the court record for the motion to dismiss. They could have done it just if Brennan was like, oh, we rewrite something, or they overwrite everything every 30 days. That could have been just as much, and it would have saved Karen Reed $12,000. Edward, this is why Lally is probably going to have to testify in an evidentiary hearing for the motion to dismiss. Oh boy. I'm pretty sure. I think they should ask for that. I think the defense should request that. We'll see whether or not it gets granted. Fran, the keeper of the video is the retired detective. He knows something about someone. That's why he kept random videos. Can't confirm or deny this, right? Because chunks keep getting slow played and slow rolled out.
Business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he
It sounds like that's what they think as well, that Brennan didn't know, and that's what happens.
contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can look all.
Again, could be nefarious, but like you would think the police chief would know about their policy and procedure, right? And would have told him that if that was the simple answer when the expert showed up.
You want to. The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? I said, let's defer that because this is literally, these are the contours of the motion that's going to be before the court. And I still want to defer it because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that because I still want to have some transparency on that process.
And I like the judge's idea there. She's like, let's not spend another 12 grand, okay, regardless of what I decide. And maybe she'll make them split it. Maybe she'll make the Commonwealth pay half. I don't love that. I think they should pay the whole thing personally. But can we come up with a cheaper way to do this where you guys pick a videographer, he turns on the video, and we film the download so everybody's on the same page about exactly how this happened? I like trying to find solutions and not just hammering one side as a judge.
But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case.
I love prepared lawyers, okay? This has nothing really to do with whether it's a winning argument or not, but one lawyer said you cite a case. Like, no. I read a case that the judge cited in the case I cited, right? Meaning that the judge in the case that agrees with what I want to do, he cited all these other cases, and that one was one of them. And Brennan said that one's good for him. But even with that case and citing that case, this judge ruled in the way I'm asking you to rule in this case, which is exactly the point. This judge did the same analysis with the case that Brennan wants to say I cited, and he came to the decision I'm asking you to come to today, Judge.
And the ultimate opinion of that court was when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court, blatant discovery and Brady violations. The court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one told it. I wasn't the one that downloaded it. I wasn't the one that downloaded it. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately at her cost, and that's what.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said.
Another great question by the judge. Is it true what Mr. Brennan said, that you guys both agreed that it was highly unlikely that the information would be there? I'll back it up so we can hear it again.
That's what.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well,
So he says, I was concerned because I didn't know what the override protocol would be, but who cares? To me, I would care if I was the judge. If you knew there was a 50-50 shot, or maybe even worse than 50-50, that you weren't going to get anything, and you still chose, when I say you, I mean the defense, to pay the money to send the expert out there. Now, if the Commonwealth or law enforcement knew with 100% certainty it didn't exist and they didn't tell you, they better pay the costs. But you can assume risk. You are allowed to waste your own money if you want to, right? In America, free country. We're allowed to waste our own money if we want to. So if both sides were like, yeah, nothing might be there, and you spent the 12 grand, well, that's a risk you're willing to take. Michelle said, is Hank regretting not watching the first trial yet? Do we have confirmation that he hasn't watched the first trial?
Override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that?
So those are two different arguments, in my opinion, and they're 100% right about all the Brady stuff. Should have been turned over, whether you asked for it or not, whether you preserved it or not. You have to turn that stuff over. It's exculpatory. It proves potentially a very star witness for the Commonwealth lied about very important details the night of the crime. But the specific cost reimbursement, it's amazing how we get into these details and the lawyers talk about what they said, and it becomes a lot more gray than it sounded in a motion, which I tell you to expect.
In the file, where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February 2nd after arraignment.
Here?
Wherever you're in.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed? And did Mr. Brennan
No,
actually?
I haven't seen it. I know it's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I
so-
just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court
I may have filed it as an
as an
exhibit.
attachment, but it was
but
never
not-
any.
Right. There was, I don't mean to cut off the
No,
court,
no,
Judge.
it was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on, I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court.
Okay.
That is in our record.
So I need you to find that.
So I haven't seen that with my own eyes. I've seen some motions to preserve and things like that, but there's no doubt in my mind they've asked for it, right? There's no doubt in my mind they filed motions to preserve it. No doubt in my mind. But I'm glad that Judge Cannoni wants to see it. She's not saying it doesn't matter. She's looking to see, and if it's there, which they say it is, sounds like she's going to take that under advisement and making her decision. All of this to me is pointing to her granting their motion, to her ordering the Commonwealth to pay those costs. That's what it sounds like. If it exists the way procedurally, the procedural history is the way that the defense explains it. That's what it seems like to me.
Happy to do it.
And tell us when it was filed, the act. I need to see.
By the end of the day today, you will have whatever submission.
Yeah, I saw the list where it says that she denied it, but it was a whole list of things. I'd have to look at it closer to see if she specifically denied the preservation. And it's interesting, right? Because I've had cases where you write the spoliation, or it's not even a filed document. Somebody doesn't have to like order it or deny it. You still have to preserve it. And if you don't, you can get a jury instruction that it did exist and you were in control and you destroyed it. So I want to see the motion that they file and the procedural history they put in the motion and the arguments they make specifically for Massachusetts. So I'm very interested to read that one.
We provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Chair.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamp. My point is, even if that weren't the case, and it is the case, the obligation is self-executing. That's what Justice Gaziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has, or a prosecutor has, to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that, and they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that information existed, the DVR existed, the video footage on the DVR existed, and we were going out there to know. We shouldn't have had to jump through this hoop and go on this wild goose chase.
So I get what number one bailiff is saying, right? It's still trickling out. So they're like, hey, maybe something does exist on there. I get it.
Expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. And I'll send that.
Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage that's recorded. That has been
That
searched.
commonly is overridden every
Yes.
30 days,
That
like
has been overwritten.
statewide police departments.
Yes, Your Honor. And that has been overwritten,
Okay,
and there is no information on that.
okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy. And it seems in this case, there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether...
Because why would they do that? And his explanation here is something I referenced in the beginning, which is law enforcement loves to do stuff like this. It's like, oh, we copied parts of it. And it's like, oh, there's a certain part that we're going to use as evidence and everybody's going to allow us to use it because it was copied through our system and it's in our Sallyport video and it was downloaded to our iCloud account. But it's like, we didn't reserve or keep all of it. Nobody told us to keep all of it. We overwrite every 30 days. It's like they hide behind these things that they do that sound appropriate. And it is potentially evidence that could help bring justice and convict a guilty person. But why not just do it the right way? If you're going to preserve part of it, why not just preserve the whole thing? If you have an open investigation and this is video of what you purport to be the weapon used in the crime. But this is not the first time or only time law enforcement does things exactly like this with video or other evidence. They're in control of it. They do what they want with it, and the defense is left to try to figure out what they can do with what's there. Azam, if it's proved that these chunks of video existed during the first trial and the Commonwealth did not turn them over, can the judge dismiss the second trial? Theoretically, she can. I want to reserve a lot of the conversation about that until we read the defense's motion to dismiss, which I'd be willing to bet there's going to be a lot of discussion about this video and the police misconduct. Edward, they went through and did a whole list of them. She ruled on them 10-5-22, so it does exist. She ruled in the margins. I saw that. I did read that. I didn't read all the context before and after it, though. That's why I just don't want to jump to conclusions on anything without having thoroughly looked into it. But I understand the document you guys are talking about, and I have seen it.
Whether there was a request for it, the obligation of the Commonwealth, I think is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he's told me is he would routinely make copies of what he would provide to the court in the Commonwealth, or the Commonwealth.
Just the reason my brain, I'll just tell you, okay, and take this with a grain of salt. Like my brain is going when I see that motion where it was like denied for all this stuff. It's like, well, that doesn't mean they don't have to preserve the evidence in the case, right? Denying whatever that was, because that's unusual. That doesn't happen in my cases where you have this list of like preservations and then the judge just says rights denied and signs the bottom in her handwriting. But to me, that doesn't mean, okay, let's destroy all the evidence we don't want. They don't have to do that. They don't have to do that, right? That's the problem. And, you know, if whether or not you file a preservation of evidence, you still have to keep the evidence. You can't destroy the evidence. If you do, and it's Brady and it's exculpatory, you have all these issues. So it's kind of like a circular argument, and that denial of the preservation doesn't really mean a lot to me. It doesn't mean they could have destroyed evidence because the judge denied whatever that list was, right? I don't know. It's just my my thought initially, but I'm still thinking through. I'm still chewing on it, as they say.
Granted, he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he's provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right. So I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right. I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
So she says, let's do it within the week. So, and she said, regardless of how I order on this or how I rule on this, I think she's going to reimburse at least some of the costs. And I hope she does. I hope she reimburses all of it. Then they get into clarification on the warrant for Miss Reed's phone. Brennan talks about it first. Then Jackson said, I misunderstood what Brennan wanted. I thought it was broader than that. It seems fine. So the judge said Brennan gets it immediately. The reciprocal discovery on ARCA, they have a very long sidebar about it, a bench conference about it. Don't know what they say, but basically the defense is like, yeah, we'll give it to him. And then they talk about the new discovery. I wanted to play a part of it. After all the ARCA stuff. See if we can get to them discussing new discovery here for a second.
Regarding expert witnesses relative to, and it is now in compliance this morning. Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCA experts. Those requests are consistent with information that we routinely provide.
So he mentions the new experts and the big dump that they provided.
Notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. There, I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it went
full-throated. It's going to be full-throated, their motion to dismiss. But I want to just play these little snippets. And then I think Brennan, again, later in the hearing, I got to go here in about 2 minutes, but again, later in the hearing says it was voluminous. 12 to 15 categories, not documents. Multiple people they've never heard of. New expert witnesses, right? It's February 6th. This hearing was this morning. All this new discovery just dumped on the defense. And now the state's like, where's our evidence? Where's our reciprocal discovery? It's like, yikes. How are they possibly going to get ready for all this? And they argue about when is their motion dismiss going to be done. They said there's no way we do it in a week. They asked for a month. The judge gives them, I think, like 2 weeks. The 21st is when it's due. And then the government has, or the Commonwealth has 7 days to respond. And from my perspective, this just seems impossible for the defense. Okay. This case is 5 years old, or what is it? 3 years old, whatever it is, 3 years old. And now they're just getting all this brand new discovery for the very first time. Seems unfair that they're only going to have 5 weeks to prep it, basically, and to file any discovery motions they need or Daubert motions that they need if they want to strike a witness, to have a hearing, all this before April 1st. With a normal judge, under normal circumstances in places that I practice, I would say the chances of this going to trial on April 1st would be slim, like less than 25%. But because we have the procedural history in this case where both sides agreed and filed a joint motion to continue, and the judge denied it with the FBI investigation going on and the first trial on this case, I think Judge Cannoni is going to push and push and push and do everything to make sure this trial starts on April 1st. All the way up to where I would actually be surprised if it gets continued. I will be surprised if it doesn't start on April 1st. Which is, if you know me and you know how we cover these cases, and usually I'm right about this because I usually guess it's going to get continued. And guess what? That's the norm in these trials, is that it gets continued. So I'm going to hit a few questions here before we go, but please hit that like button. We got some overtime in today as well. And make sure you guys are all subscribed to our YouTube channel. If you haven't yet, would love to have you around on all these videos. Edward, yes, but the 10-5-22 is her approving the renewed evidence preservation. That's why his argument is even dumber. Peter, the Young Jerks had CTV video. Her name is Abby, and she went over Sally Port videos and how it was inverted. Okay. Nina, the previous judge ordered the preserve all evidence on February 2nd, 2022. Watch the video of her arraignment. It's on the record. Yeah. I mean, that's not rocket science, right? They've got to preserve all the evidence. A judge shouldn't have to order you to do that. Thank you for telling me that, though. That is interesting on her initial arraignment. This video is what they wanted the first trial, but CPD downloaded it and cut it up. And how does this retired guy have the unedited version? That makes no sense to me. And like I said, I expect it to be a big portion of their full-throated motion to dismiss. To pose the retired guy and his hard drive. Yeah, I mean, it seems like there's still a lot of work to be done between now and April 1st. Will they get it all done? I don't know. We'll see. What do you guys think? Let me know in the comments. But for now, that's all we got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.